This is an appeal in the matter of M, a child.
Yes, Mr. Norton.
My lady, my lords, I appear on behalf of the appellant, whom I'll refer as the mother throughout. I'm assisted by my lady, Dr. Love, and Miss Wills, who instruct us. The mother is present in court, sat at a place outside of the view of the camera, on the understanding this is a live stream hearing. The first respondent, the local authority, represented by my friend Mr. Howe, King's Counsel, together with Mr. Froud, assisted by those who instruct them, Miss Crowther and Miss Kirsch, the allocated social worker. The respondent child is represented by my friend Miss Farrington, King's Counsel, together with Miss Chan, and those who instruct Miss Carter Birch is in court. There is a further party, the maternal grandmother, represented by my friend Miss Rahman, assisted by Miss Berry today. The grandmother is also present in court, sat next to the mother. My lady will be aware that there are other parties to the Part 31 proceedings who are neither present nor represented at this appeal hearing. But there has also been intervention by two bodies by way of written submissions only.
Yes, we have. Thank
Family
you.
Law Bar Association, a document prepared by Miss Reed, King's Counsel, Mr. Holmes. In fact, Miss Reed is in court as an observer, but not as a representative, as it were, of the intervener.
Yes.
And the ALC, a document prepared by Miss Gidding, King's Counsel, Miss Roberts and Miss Bennett.
Yes.
My lady, may I first confirm that the court has those documents that we hoped you have. Some of those have come in relatively recently, in fact yesterday. There should be a core bundle
Yes.
numbering some 123 PDF and real pages.
Yes.
A supplementary bundle numbering 239 pages. There is what we have is a revised authority bundle, which is 110 pages.
Yes.
And then there is, I think, the document that came in yesterday, or bundle that came in yesterday, a supplementary authorities bundle of some 122 pages. And that arose as a result of the submissions received on behalf of the FLBA and the ALC on Friday of last week. Both of those submissions, I don't think, my lady, have found their way into any of the bundles,
No.
but are separate documents of some 15 and 14 pages respectively.
We have
are
those,
the
thank you.
documents that the court should have.
Yes. Yes. Now, one of the things that we've been thinking about is how best to manage the appeal,
Yes.
dividing effectively as between the law and then the application of the law to the facts of this case. I don't know if you'd had any discussions as between you how you were going to manage it and whether or not you were going to go along the line. Well, you're obviously going first and you're more or less with some nuances agreed, but whether or not you intended to deal with the law first and then everyone would deal with anything they wish to add to that before we then turn to the actual appeal itself.
Well, we are, of course, all in the court's hands. I had anticipated dealing effectively as for the appellant mother on the appeal itself and the reasons why I say that the learned judge made the wrong decision on the 15th of January, addressing the matters specific to that issue, leaving others to deal with the wider issues, as it were, in respect of the law and the test, although I was intending to address those matters. If the court wishes us to approach them in a different way, of course, we will endeavour to do so.
Well, I don't wish to undermine the way you'd hope to deal with the matter when you've prepared it. But if I can just make it clear that we do want the legal context very firmly established, and to be very clear about that for all our parts.
My lady, certainly, in addressing the appeal issue and the facts related to this appeal, I certainly anticipated dealing with the appropriate legal test, and where, with reference to the learned judge's judgment, I say he misstated at times and failed to engage fully at other times with elements of that test. I hope that will assist, but of course, if at any time I am making submissions which are unhelpful to the court, I will stop and move on to another issue.
Of course, thank you.
My lady, can I first address one matter, though, as to the fact that the mother does not have an intermediary at court today. It is our case on behalf of the mother that she requires an intermediary for the proceedings in its wide sense, but there is no order for an intermediary for today. And for today's purposes, the mother is assisted in terms of following this hearing by the maternal grandmother,
As has happened in the past.
as has happened in the past. My lady and my lords would have identified that the maternal grandmother is herself an intervener within those Part 31 proceedings, and we would take the view, as I understand is shared by those who represent the maternal grandmother, that it would be inappropriate for the maternal grandmother to undertake that task during the fact-finding hearing when she herself has to engage with the proceedings and provide instructions.
I couldn't pick up when the grandmother became a party.
My lord, I'm going to turn my back for a moment. June or July of last year.
So that would have been possibly after the first case management hearing.
Oh, I'm so sorry. I'm told the 14th of August, my lord. Sorry.
14th of August,
Yes.
okay, thank you.
Yes.
Yes, it's in the chronology.
Thank you.
I should indicate also, so the court has this appeal orientated within those proceedings, that the fact-finding hearing is now listed, I understand, in dates towards the end of September of this year. There is, next week on the 25th of March, a further case management hearing before His Honour Judge Thomas. My lady, in terms of the case for the appellant mother, we have set out in our document 4 grounds. What I propose to address that would assist the court are 2 effectively broad strands, as I say, can be taken from those grounds. The first is, as I say, our challenge to His Honour Judge Thomas's assertion of the law and his engagement with the required rules. And secondly, allied to that, a failure, we say, properly to engage with the evidence that supported the appointment of an intermediary throughout these proceedings. I will say, or I say on behalf of the mother, that even if one applied a test of exceptionality, which I do not accept as the test, but even if one did apply that test, in this case, these facts would support the granting of intermediary for the mother. In terms of the relief sought, we had in our documents invited this court to set aside the refusal, and at the time of the documents invited the court to grant a stay. Because matters have developed in the way that I've outlined, we invite this court to set aside the refusal, but to direct that there is an intermediary for the mother through proceedings, in light of the fact that there is a case management hearing on next week, which we say the mother ought to have the support of an intermediary at that hearing.
What do you mean by proceedings? Do you have a draft order?
I don't have a draft order, my lord, but I would, in that order, set out that the mother ought to have an intermediary for all future court hearings, unless and until it was determined that that was not necessary. It seems to us on that.
So you draw the line at court hearings.
Well, I will address this matter, my lord, in a moment, but the rules require consideration not only of evidence, but during the proceedings. We take the view, as I think do the ALC and the FLBA, that proceedings is a wide term, and therefore that could encompass the taking of evidence and in terms of conferences with one's clients, because engaging in those matters, in conferences and the like.
Whether it could encompass those other matters, are you saying it should in this case?
It should in this case, yes.
So you're not limiting it to court hearings?
Not court hearings, no, not just the court hearings, but the proceedings up until the judge were to make a different decision. It is, I think, all of our parties, I will not speak for all the others, but it is our position that, of course, this issue is a case management issue which is capable of being revisited should circumstances change. The decision made on one day doesn't necessarily mean that that decision stands throughout.
I was simply trying to tease out what you mean by proceedings.
I ought not to have limited it to hearings. The rules require proceedings and evidence. And proceedings, we say, takes a wider term than simply attendance at court hearings. May well encompass the taking of evidence by way of a consultation with the client and the preparation of written documents and going through the written evidence of others. If it is limited to a court hearing, there is a risk that in a particular case, a party may attend that hearing without understanding all the written material that is before the court at that hearing.
Certainly speaking for myself, I hope you're going to come back to the rules and the evidence in those respects.
I will endeavour to do so. It is in my expectation to do so, my lord. If I forget, I'm sure my lord will remind.
There's one other thing. It may very well be that if you were right that an intermediary was necessary, it would be necessary for the entirety of the proceedings. But one option, as it seems to me, is for this court, if it made any order in your client's favour, would be to say that the order would endure until the end of the fact-finding process, and then the judge would then be in a position to decide whether it should continue thereafter. That must surely be an alternative.
Yes, yes, my lord. There are obvious stages. This judge had permitted an intermediary during case management hearing, but determined in January that it wasn't required for a fact-finding hearing. But my lord makes the clear point that, of course, at the conclusion of the fact-finding hearing, the landscape of the case may be very different and not require an intermediary throughout future hearings.
Right, so if, obviously it entirely depends, but if you were to succeed in obtaining an order for an intermediary, it wouldn't particularly grieve you if that order lasted until the end of the fact-finding process, with the judge then to consider where to go from there.
It would not.
The provision that was made for an intermediary up till now at the 3 case management hearings, was that the intermediary present, obviously, at the court building and in the conferences?
The intermediary who was present on the 15th of January
Yep.
had not been the intermediary at the earlier case
I
management
recollect that,
hearings,
yes.
but she was the author of the intermediary report.
Yep.
I'm going to turn my back, my lady, if I may, just to confirm the position with respect to consultations and
Thank you.
Dr. Love confirms that in terms of the engagement of the intermediary, she was present outside of the courtroom with Dr. Love and the mother, so not just within the courtroom, as is sometimes the case. I'm going to have instructions passed to me over the course of the hearing as to whether the intermediary was engaged, as it were, outside of the courtroom on days other than the court hearing, which I think was my lady's question.
Yes, because there's 3 things, aren't there? There's physically in court and limited to that. There's in conferences in the court building and then going into court. And then there is the extreme of in the solicitor's office, away from courts on separate dates, and then in the conferences and then in the court. And I'd like to be clear for my part.
Those instructions will be taken.
I think your junior's trying to tell you something.
Oh, sorry, thank you. In this case, the intermediary was not present in the conference with the mother outside of the, away from the court building.
Thank you.
What is he asking for?
What are you asking for?
I am asking for an order that there is an intermediary to assist the mother at court hearings.
Yes.
I accept that that potentially could be time limited up until the conclusion of the fact-finding hearing.
But you're not
I
asking.
invite-
I'm sorry.
And in addition, there ought to be an intermediary present at a conference or conferences with the mother for the preparation of her evidence for the hearing and to go through the remaining evidence.
So outside, away from the court building, in your solicitor's office.
Yes. Well, that is on the basis of this particular case where this mother requires that support. I'm not saying that that should be the position in all cases. And it may be that the court forms a view that that is a participation direction too far. But that is what I'm inviting the court to consider at this hearing, if the court is able, of course, or whether that matter needs to be remitted to wider courts.
Thank you.
But it seems to me, Ms. Snowden, that you would have to, if you were asking us to make an order in substitution to the order that the judge made, you'd have to explain to us why it was necessary.
Yes.
I mean, it isn't going to be just a question of you leaving it for us to decide. We'd need to be satisfied that each participation direction you requested was necessary.
Hence asking for a draft order.
I beg your pardon.
Hence my question
Yes.
as to whether there was a draft order which we can actually look at.
I will ensure, my lord, that that is available should we get to that position. I apologise, it has not been made available before now. I will address, however, the details of that. So the draft.
I wasn't being critical, I was really just seeking assistance.
Could we have a draft order at lunch?
Well, it might be possible to put together a draft order over the short adjournment.
Yes. I will certainly.
Commensurate, of course, with Dr. Love getting a sandwich.
And also, yes, that certainly will be my endeavour and expectations.
Well, thank you. That would be very helpful.
Can I then turn, my lady, to the particular facts of this case, addressing, as I will in those submissions, the legal test that I invite the court to outline. It is, in this case, an accepted position that the mother is a vulnerable person. As my lady and lords know from the documents, there is no definition of vulnerability, but a requirement to engage with the elements of Rule 3A.7 in terms of the factors of vulnerability. Properly engaging with those elements, it is clear that the mother is a vulnerable person.
So you've taken us to 3A.
3A.7 is what the court must have regard to when deciding whether to make one or more participation directions. And one sees, for example, 3A.7b, the need to consider whether a party or witness suffers from various conditions.
You'd say that your lay client falls within B(1).
B(1) certainly, and there are elements in respect of 3A.7F, maturity and understanding. The learned
Well,
judge.
it's not just about the person, it's also about the challenges of the proceedings.
Yes.
And so you're entitled to have regard to D&E in that sense, because although we spend as professionals a lot of time on these sorts of matters, that the situation in which this family finds itself is very extreme, where certainly at the fact-finding stage, they're ranged against each other as to possible findings and responsibility for the injury.
Yes. And my lord, there has been some discussion outside of court as to whether it may be that an intermediary would be required just for the expert evidence, for example, to explain that to a client. Equally, one might say, in a fact-finding hearing where there are family members potentially pitched against the other or giving accounts, it is necessary for a vulnerable person fully to understand what another lay party is saying so that they can provide such instructions as they are capable to their advocate. So it would be a case-by-case basis to determine whether assistance is required, and of course what assistance that might be, throughout a fact-finding hearing, during certain elements of it, or key evidence within it.
And I think all of us that have been involved in these sort of cases are very cognizant of the fact that chronology can be very difficult.
Yes.
Putting in what fits where can be very challenging.
And in this case also you seem to have a tsunami of phone records. About, have they arrived or are they still being processed?
They're being processed by Lord at the moment.
And that was, by the look of it, was the main reason why the hearing couldn't go ahead
There are
last
other
month.
reasons, yes.
So there are a lot of instructions to be taken about whatever's in that disclosure.
Yes.
Could I ask you a question about little L? Just as a matter of practice, there's some commentary in this red book which suggests that HMCTS takes responsibility for the payment of intermediaries wherever they are. Is that in fact the case, or is it a mixture as between HMCTS and legal aid?
My lord, I can speak from my own personal experience, and others will correct me if I'm wrong. It used to be a position where routinely HMCTS paid, and occasionally a hearing would be listed for an intermediary to attend. The primary purpose of that hearing was really for instructions to be taken. My understanding and my more limited experience more recently is that intermediaries can be funded through legal aid. But I will defer to others in court and my solicitor brethren as to whether that is in fact their experience of public funds.
I think it'd be helpful. I think Mr. Housen nodding.
That's my idea. I've got the guidance as part of my submission.
Fine.
So I'll
Yes, because I think it's useful for us to be absolutely clear what. the
Nobody's
current
making
situation is.
submissions about the specific cost of this specific intermediary application in this specific case. However, the context obviously
Yes.
requires us to consider cost as
Yes.
a general matter.
Do the potential public funders of intermediaries know about this appeal and these arguments?
My lord, we have not informed them, and they have. The answer is we have not informed them. I'm not aware that they are aware of this hearing. It is something that the court might wish to consider, because there is of course, a funding implication, primarily at the moment on HMCTS for the use of intermediaries.
I mean, on the face of it, 3A7L requires the court to have regard to the costs,
Yes.
and I assume that means also, as it were, on whom they will fall. I assume it's not just costs in the sense of how much, it's a question of on whom.
It would be on whom, and of course, my lord, there is the overriding objective to allocate to any particular case a proportionate amount of any overall budget, as it were. I would say on behalf of this mother, and others are saying on behalf of other parties or interveners in this case, that ultimately funding could not be used as a reason to deny an intermediary in a case where the Article 6 rights of the individual require an intermediary is a necessary participation direction. Of course, the cost must be something that the court has in its thoughts when weighing up all of the competing aims. But ultimately, as I say, funding itself could not be the final determining factor. Really, in terms, I'd indicated that it was an accepted position by all parties and by the court that the mother falls into the category of people who require support. My lady, her particular difficulties are set out in the skeleton argument of Dr. Love. I don't propose to list those.
No. It's not necessary. We've had an opportunity of reading the skeleton argument.
What is apparent, I say, in this case, is that there was sufficient and, in fact, quite overwhelming evidence of the needs of this mother at the hearing on the 15th of January. Those who intervene in this appeal, the ALC and the FLBA, invite some consideration from this court as to the nature of evidence that would be necessary in support of any particular claim. But I don't intend to address that issue unless the court will be assisted by my submissions on that. But in this particular case...
Sorry, but I understood that Dr. Love appeared at all of the hearings.
Yes.
At the three previous hearings, or the three hearings that had taken place. And I thought that your case was that what she told the court about how the, in a sense, mother's position was being dealt with was something that the judge was entitled to take into account.
I'm sorry, my lord.
Yes, I thought your position was that what counsel told the judge about the mother's position in her submissions was material that the judge was entitled to take into account, even if in a sense it was narrative from counsel as opposed to being in some report somewhere.
That is our position.
Yes.
I think that's the position of the ALC and the FLBA,
Yes.
that requiring a formality of written evidence might be inappropriate. There might be cases where that is necessary, but that ought not to be the requirement in all cases. There will be cases, my lord, where it is abundantly clear to everybody in court and the judge that there is a vulnerability that requires the court to engage in part the PD 3AA. There may be other cases where that vulnerability is more nuanced and only apparent to those representing the individual. It has been said by others, I now can't remember who, that there is the possibility that that vulnerability will be detected by the legal team or others representing a vulnerable party, but may have been missed by professionals working with the family because of masking. So all of those things have to be within the contemplation of court making these difficult decisions. But certainly I don't, on behalf of the appellants, say that there needs to be a formality of the evidence in all cases. But in this case, there was a formality of evidence from a range of different sources.
But in addition, you would say, I think, that counsel and solicitors had represented the mother on 3 previous occasions and had seen how she had coped, albeit with the assistance of either her mother, an intermediary.
Yes.
And so it was appropriate for submissions then to be made in the light of their observations of how she had coped. And the judge should have taken or was entitled to take those into account, and there was no necessity for Dr. Love to effectively file written evidence or her solicitor in support of that.
Yeah.
I think that's your case, is it?
It is, and my lady, I would also add that which Dr. Love has set out in the skeleton in terms of the role of intermediary to date at the point of 50th of January would also have been evident to His Honour Judge Thomas, because the assistance was being given by the intermediary during the course of the hearing.
So it was visible.
Whilst Dr. Love was addressing the judge, behind her was sat the mother and the intermediary. And although this court may have been advised of experiences where an intermediary was appointed and appear not to engage particularly with a hearing, in this particular case, there was, I understand, active engagement between the mother and the intermediary throughout even the case management hearing, so that the mother was following what was happening. That ought to, I say, be evident to His Honour Judge Thomas from his vantage point.
Thank you.
My lady, in terms of the evidence that His Honour Judge Thomas had or ought to have had in his contemplation when reaching the decision, there was, of course, the report of Dr. Dowsett. That is within the supplementary bundle. I don't invite the court to turn to it unless it would assist, but it is clear from Dr. Dowsett's recommendation that contemplation should be given to the use of intermediary throughout. Of course, I don't submit, and nobody...
Throughout, sorry, remind me, throughout what?
My Lord, just so I quote correctly, I'm going to turn to page 51 of the supplementary bundle, so that we see clearly the... Page 51 of the supplementary bundle.
Relates to the court.
Yes. So, my Lord, that is one of the mischiefs that I will address the court upon, in terms of the need to address both aspects of Part 3A, which is looking at participation during proceedings and separately participation giving evidence. And one detects that on occasions those two things are linked and one is given greater attention and at the expense of the other. So both those advising the court and, dare I say, occasionally judges look at these matters, look at participation as being within the evidence-giving stage and not throughout proceedings. Therefore, as though Dr. Dowsett says in his report at page 51, I think she should have an intermediary in court, the basis upon which he says that, the following paragraph, is as much appetite to proceedings generally as it is to the giving of evidence.
Yes, although if you look at the two preceding paragraphs, they relate to, it says, in regard to the specific questions, and the specific questions are where? Are they what's in bold?
I think at the top of 49.
Bottom of
Page
Bottom,
49,
page 49, in fact.
paragraphs, yes.
which is focusing on, it is
Focus on the evidence.
it is focusing on court, what are called court hearings. So I'm not making a point, by the way, I'm just worrying away like a dog with a bone on something that I just need more education on.
Well, my lord, I would invite this court in its judgment to address both aspects of Part 3A, and on my submission that occasionally, as I say, the focus is on the evidence gathering, and there needs to be as much attention at the engagement in proceedings generally, that being a crucial part of a party's ability to fully engage with the applications.
But I think you probably have to accept that Dr. Dowsett's report doesn't specifically address the issue of the use of an intermediary outside court hearings.
But as often is the case, my lord, the psychologists will address the questions specifically asked of the psychologists and will, with some regularity, suggest the consideration of an intermediary. The intermediary within the intermediary report will address some of the more specific assistance that the party might need. There could be some greater focus on whether that assistance is needed just for the evidence gathering process or the evidence giving process or the proceedings more generally.
The reason I think I'm asking is, I hope obvious, that the court environment is familiar to us but alien to most normal people and stressful.
Yes.
And it's
Stressful to us as well, my lord, on occasions.
Surely not.
Carry it well. But engagement with a client and their lawyers in a different environment with more time is a different environment. It's a different environment that creates different dynamics and might mitigate some of the concerns that are imposed necessarily by court proceedings.
Yes.
So it doesn't follow that somebody, and I'm not talking about this case, it doesn't follow that because somebody might need an intermediary in the rather more alien and pressured court environment that they also need one in the external evidence gathering stage, as you put it. It doesn't follow.
It doesn't follow automatically, my lord. I accept that. It must be a specific consideration. Look at the participation that a party needs when giving their evidence, and secondly, look at the participation they need in the proceedings generally. And as my ladies observed, that might be proceedings generally in court, but that might also include proceedings generally outside, away from the court building. And as my lord has rightly observed, in that setting, different factors apply. There may not be the time pressure. There's a more familiar environment. All of those matters can mitigate the need for assistance of an intermediary in some cases, not all.
And am I right in thinking that what the judge was asked to order is something less than you are asking us to substitute?
Yes. Well, the judge was not asked. Just confirm. Dr. Nav says, in fact, the submission was for intermediary during the fact-finding hearing and in conference.
And in conference at court or in conference?
Outside of court and in court.
And that was made, this is not critical at all, but that was made clear to the judge, was it?
Dr. Love, I may have heard, she won't attest to how clear that submission may have been.
Yes.
One of the matters I was going to address, and I'll address now if I may, is the recommendations of the intermediary assessment. A matter which has become apparent to me, having not been present at that hearing, was that the intermediary assessment was not within the bundle of papers before His Honour Judge Thomas at the start of the hearing, and was emailed separately to him during the course of the hearing. And
well, one of your criticisms is that he didn't rise to actually read it.
yes. It's a criticism made with some caution because I recognise the time pressure on all judges, circuit judges in particular, dealing with these cases, and the overriding objective to give a proportionate amount of time. But equally, as is apparent from the judgment, having not taken time to engage with the detail of the report, it is difficult to discern the particular factors that the lone judge took from the intermediary report in reaching his conclusions, and I'll turn in a moment to the judgment.
Just staying with the framework for this for a moment. This discussion is showing how important it is to be specific about what you're asking for and also what you're getting, whatever that might be. I mean, it strikes me that one way of approaching this would have been, had the judge thought an intermediary was necessary, would be to say, fine, there are going to be X hearings between now and the end of the fact-finding hearing, and those are matters for which an intermediary should attend, and that if there is some important out-of-court building event, a conference with counsel or something of that sort, the drafting of an important statement, the taking of instructions on a mass of evidence that you need instructions upon, then ask. And the direction might turn out saying that there could be, in preparation for a hearing, one occasion for a meeting for preparation for trial or whatever it is. But it strikes me as being quite difficult for a court that is bound to control expense apart from anything else to simply say there will be an intermediary during the course of proceedings that are slated to last for months. Isn't the proper way of approaching this for the person who is asking for an intermediary to come armed with what they foreseeably need? Of course, things can change, but what they foreseeably need, and for the judge to say yes or no to any or all of those. So that in your case, I don't imagine you're asking for carte blanche for any number of meetings, but I can see that you might, if it was proper within the rules, say, well, there's an important meeting which isn't a court hearing, and I need an intermediary for that. But shouldn't it be broken up in that way?
My Lord is right, I don't seek to submit otherwise, that there is an obligation not only on the court to engage in what elements of an intermediary may be required for, but the parties and advocates to assist the court in that process. And so clarity as to what is being asked and why would be a prerequisite. As my Lord identified, it may be that it can be made clear that there are specific tasks which need to be undertaken which are particularly sensitive to that individual that require the assistance of an intermediary. As my Lord has identified, there may be occasions when that is not necessary.
Well, and it goes back to my point earlier. In my more normal stamping ground, the words draft order, where is it, are frequently used, and I don't, on the whole, see that this should be any different. I mean, some sort of piece of paper, in any event, with a list of the requirements, will assist everybody to focus on what is being asked, and indeed what might have been missed.
My Lord, I accept that, and I would in fact go one stage before that in terms of careful consideration being given to any instruction if an intermediary assessment is to be invited, to be clear as to what issues that assessment should address, because a generic intermediary assessment that this individual requires an intermediary, full stop, is of little use to those who are instructed by the party and certainly to the court. And addressing, as I say, both the elements of proceedings, evidence, what is required and why, will assist the court and those advocates who have to then produce the draft order that would be taken to a court hearing.
I mean, in practice, when everyone's far too busy and has far too little time, is what happens, generally speaking, is someone makes an application for an assessment, an intermediary assessment, and it's kind of either yes or no, and the sort of detail you say should be described in the order permitting the instruction of an assessment is often not there.
Not there, my lady.
It's just a general please assess.
I'm conscious that I'm addressing the court on behalf of my client, and there are other parties who have given more general provided intervention on behalf of ALC and the FLBA who may have other observations about that. That's certainly my experience is an order for an intermediary assessment. That assessment comes in. It's an application under Part 18, not Part 25, and as a result, the focus perhaps on the letter of instruction and the questions may not be as much as is the case in Part 25 applications.
Although it does appear from the pages you were referring us to, at least in relation to Dowsett's report, that there were specific questions that he was asked.
There were specific questions in terms of the psychologist,
Yes.
because that was a Part 25 application. I'll turn my mind a moment to the application for the intermediary assessment. I should say,
What you're suggesting, I think, is that the same sort of approach ought to
the
apply.
same sort of approach ought to apply, but I should say, and my lords and lady will have a view about this particular intermediary assessment. It is thorough, detailed, and quite focused on the specific steps that this mother requires. The court may have experience of other reports which are a little less detailed and less focused on the particular participation that is required.
I mean, I'm sure that we're all against multiplying tasks for people in these proceedings, but on the face of it, although an intermediary is not classed as being an expert, the engagement of an intermediary is just as important and may in many cases be more important than the instruction of an individual expert in a, as to tooth decay or whatever it is. There may be some benefit in the process that is followed in relation to experts being mirrored in relation to intermediaries, because it does draw out exactly what it is that is being asked for and why, and make it easier for a judge to discriminate between yes or no, just taking a general view. There'll be cases where the court can consider the matter without the need for a formal application, but in a case of this sort where it was obvious from the beginning that your client was a candidate, I don't on the face of it see any particular burden or difficulty in there being a formal application that says exactly what's being asked for.
My lord, I wouldn't want to overcomplicate matters on the basis that
No, but I think it's in order to simplify matters, really, in order to, taking my lord's point about the draft order.
it may simplify matters by focusing any intermediary assessment on part, sort of Rule 3A.4 and 3A.5
Yeah.
to direct the intermediary to address both of those elements, and then some simple questions: what do you say is required and why? And perhaps also what other measures might be taken in the event that a particular participation direction is not available. It could be a relatively short letter, and one sees from the community court report that they are alive to changes in law. They make reference to authorities, so they are clearly aware of the focus, and I'm sure would follow guidance from this court in terms of the process that they should adopt and produce the report.
Are you going to take us to the intermediary assessment, by the way?
I was, my lord, going to take you there on a slight tangent and just invite my lord to look at supplementary bundle page 104. And I preface that by making it clear that this is a document that has been produced since the hearing and therefore the report is not before the court.
But, okay, are we going back to the actual?
Go back to the report in a moment.
Well, you've delightfully described it as a tangent. I mean, in fact, it's what we would call fresh evidence, and I'm not sure. I mean, clearly, everybody was quite surprised by this decision, and the intermediary was bestirred to write a quite long letter about it. But is it appropriate for us to read that?
My lord, I don't wish to do anything which is inappropriate, but can I preface it by the reason for inviting the court to consider that document is that Judge Thomas was aware that the author of the report was present in court and was provided with the opportunity to ask the intermediary questions arising from the report, at which I say those elements that are in the letter
Yes.
would have come out. So it's
The
evidence
fact
that-
remains, this is fresh evidence and the application's been made.
Yes.
It's not, in a sense, it's not fair to the judge to, I mean, your point is, it was perfectly open to him to engage with the intermediary. He wasn't obliged to do so, but it was perfectly open to him to do so. He didn't. And this is, as it were, in its existence, evidence of the sorts of things that he might have been told had he asked.
Yes. Well, my lord, I won't then focus on that, and I'll take my the court and my lord back to
Well, I mean,
the report.
I think that's just my impression. I have to say I haven't read it. I've seen it's there.
Yes. I won't descend into detail if my lord hasn't read it. I don't want to in any way adduce evidence which is inappropriate at this appeal hearing, and take my lord back to the communal court report.
Well, I think you can easily make the submission without us having to turn and read that document. In fact, you made the submission.
Yes. That evidence would have been available,
Yes.
and the opportunity was afforded to the
Intermediary is in court. She knew your lay client.
Yes.
Questions could have been asked, particularly given that the judge hadn't read the report.
The report itself can be found in the supplementary bundle. That's most helpfully turning to page 57 of the bundle, which is the summary of findings.
Could you assist me, under the bold underlined conclusion at 2.3?
Yes.
Can you assist me as to where in this report the intermediary deals with the justification for including any conferences relating to this case?
My lord, at page 59 of the bundle, internal page 7 of the report, there are the, in tabular form, the difficulties for the mother and the proposed steps taken back during proceedings. Generally, if one looks, for example, at literacy in section 21 on page 62.
Could we just go back first, because conferences are mentioned in page 58.
The reason I asked is because the report is broken into, very helpfully and logically, recommendations, for example, for preparation for the hearing, which is 5, starting page 65, and then recommendations for during the hearing, and then recommendations when giving evidence, it's part of 7, and then recommendations for after understanding the judgment. But I just didn't see any equivalent consideration to those. There's nothing, well, I can't see anything equivalent to that level of analysis to justify the recommendation for the use of an intermediary in the preparatory stages. I'm not making a point, I'm just trying to identify that this doesn't seem to have been the focus for the intermediary assessment any more than it was for Dr. Dowsett's report. It might have been mentioned en passant, but that's pretty much it.
Well, that might take me back to my earlier submission in terms of the need to be ensure that an intermediary report addresses all of those factors that my lord has outlined. Lord Peter Jackson has helpfully identified in paragraph 2.8 the reference to use of an intermediary in conferences, but at page 62, paragraph.
Well, you could go to page 60, in fact, under the heading receptive vocabulary, which also does mention conferences. So I'm not saying that there aren't mentions of conferences throughout this, but it doesn't seem to be part of the logical focus in the way that the remainder of the report is. And I'm just identifying this as a point to perhaps be thought about.
And again, we don't have the specific difference between conferences at court and conferences at the solicitors. And just picking up from that, I see at 5.1, Mr. Norton, a suggestion that there's an additional visit to see the courtroom before the hearing with the assistance of the intermediary. Is that commonplace? I'm well aware that very often litigants are taken to court to see bound. I mean, I understand that completely. But, is that a frequent task for the intermediary?
In my experience, and others may have a different experience, my experience is that task is achieved during a case management hearing when the intermediary is present. So there may be a visit to the court has already taken place. Frequently, in my experience, and it is simply that, an intermediary will use those opportunities to familiarise a party with the court building, the courtroom, and occasionally the mechanical video room, those sorts of matters. So rather than a specific separate meeting, that is my experience.
Yes.
Others may have a different experience.
Thank you. So we've taken you out of your course again.
Can I invite the court to indicate whether there are further aspects of the intermediate report to which I should draw the court's attention in terms of the evidence that was and ought to have been available to the judge in making his determination? Otherwise, I was going to move on to the judgment.
I think the judgment does show that the judge had the opportunity to take into account the intermediate report to some extent, because he lists the tabular difficulties. He could have it in front of him and had got that. So it's not entirely clear how much time he was granted to look at this, why he hadn't had the report in good time, all of those matters, but he clearly did his best to some degree from reading the judgment.
Well, I'm not going to appear at court to criticise a busy circuit judge undertaking as they do the task of case management of a hearing, no doubt, with other matters on the list, and a range of factors one sees from the end of the judgment. There was other case management issues that the main judge had to consider at that hearing.
I don't quite understand, seeing as this is 24th of July, how 6 months later the judge hasn't had the intermediary report. He'd conducted other hearings, hadn't he?
I understand that the report had been filed, but hadn't made its way into the bundle. So whether the judge had had the opportunity to read it before that hearing, but at the hearing, Dr. Buff tells me that the report needs to be reset to draw it to the court's attention.
So it had been filed but had not arrived with the judge on that occasion.
Into the bundle,
Thank you.
But picking up my Lord Justice Peter Jackson's comment about the tightness of time, I've got the order turned up and seen all the different considerations, orders, assessments, applications that were made, and it was all done, we can see from page 101, in an hour.
Yes.
Including the extempt judgment. And it's a good picture lens onto the pressure that the courts and advocates are under.
With that caution, my lady, I turn to the judgment, and having had the benefit of time to go through that judgment line by line, criticise the learned judge for some of the elements of it. The learned judge highlights, sorry, my lady, judgment. The transcript of judgment is within the core bundle at page 103. Lady, one sees at paragraph 5, frankly, the judge identifies the test we all inviting the court to confirm, which is a two-stage test as broad BBS. Is there a vulnerability? And if so, the judge says, is there necessary for there to be an intermediary? It's a shorthand for the rule. Is there necessary for participation directions, amongst which might be an intermediary, and if so, in what way? The learned judge then outlines in the subsequent paragraphs the relevant rules, practice direction 3AA, mindful, he says, of part 3A, we need to consider a number of factors as set out in 3A.7, although those really go to the issue of vulnerability rather than the participation directions. Having gone through that stage, we see at paragraph 18 on page 106 the conclusions, again with respect to the judge dealing, notice observed with a busy list and a number of matters within the hour, no analysis in reality as to why that conclusion has been reached, and nothing within the judgment setting out the participation directions that could be made short of the appointed intermediary to assist this mother in this case. What I do say is that although clearly in paragraph 5 the learned judge identifies the test of necessity, one sees over the page at 105 of the bundle reference in paragraph 10 to 13 a consideration of case law, both the decision of Mrs. Justice Leven and Mr. Justice Williams in the Northamptonshire and X and Y cases. And I say on behalf of the mother that what is apparent from those paragraphs is the focus that the judge had on the exceptionality of such a determination and the rarity. Because although paragraph 5 deals with the test, one then has more paragraphs 10 through to 13 looking at the exceptionality of it in paragraph 10 and the reference in X and Y in very rare cases. And what we say on behalf of the mother, and what all parties and the interveners in this appeal invite the court to determine, is that the test is one set out by Rule 3A, assisted by Section 3AA. It is one of whether participation directions are necessary and should not be clouded by any additional tests of exceptionality or compellable arguments in support.
Just going back for a moment to the length of the hearing, it's 10 o'clock to 11 o'clock. I'm sure that council who were in attendance will probably remember. It has all the complexions of one of these hearings that's put in the middle of a trial that would then have continued.
Because it was 10 till 11:05, wasn't
10
it?
to
So-
11:05. If there's any reason to displace that assumption,
Grant's recollection is that the issue in relation to the intermediary took about 10 minutes. Took about 10 minutes. of
absolutely. But
the-
I'm more talking about the fact that looking
Squeezed in.
at the judge's diary on that date,
Yes.
one might assume that having risen from having dealt with this directions hearing, he then probably went back to his trial.
That would be it. I just heard. Tim said it appeared to be a day of back-to-back case management for that hearing. Of itself, particularly difficult because of the need for the reading and grappling with each of the issues in each of those cases.
All right, thank you. This was not a case in which at any stage there had been a formal application for intermediary. The way that it had started was with successful application for an assessment in the summer, and then matters had continued under that flag. Subsequently, once you got the intermediary assessment report, you didn't file a formal application at that stage.
I believe that's the case. More than just check this. One is right.
Yes.
Maybe coming to it, but took us to the references to the authorities. And when I read the judgment, I was surprised at 12. Re XY, only towards the far end of the spectrum will there be cases where an intermediary is necessary for giving evidence. And when I read that, I thought, well, isn't that back to front? Because isn't the most likely consideration being to help someone give their evidence? I mean, the whole premise is to facilitate people for giving their best evidence. But then when I just reminded myself from Mr. Justice Williams' actual report or the judgment in that case, and in fact, actually, what one's instinct's correct, because when you look at it, what he says, the spectrum vulnerability will self-evidently be wide. Only towards the far end will there be cases intermediary necessary for giving of evidence, which is what we have here. But then it goes only at the very far end is it required for the whole hearing, and only in the very rarest cases necessary to give instructions in advance. So, so he's not saying there that the most unlikely is for giving evidence, which is how it might be thought to read initially.
And that, we say, is a flaw in the analysis of the judge, in that he looked at the issue of exceptionality and rarity. He took from the Northamptonshire case and the case of X and Y a need as a principle for only to do so, only to grant such orders in rare circumstances, without fully engaging with Rule 3A and perhaps Direction 3AA, which ought to be the starting point.
It's sort of good, better, best, isn't it? It's rare, very rare, most rare.
I mean, what we say, and I think all parties and interveners say in this case, that the rarity should be the consequence of a proper application of the rule and practice direction 3A and not an objective in itself.
Given a test's necessity.
Yes. My lady, I'm conscious of the time. I've addressed from the mother's perspective the facts of this case and the reason why I say that in this case not matters failed properly to pass the appropriate test. I can move on to issues in relation to the Northamptonshire case and X and Y as more general principles, if that would assist the court, although I'm conscious that others also have their submissions. And
Well, subject to my lord's view, for my part, I think I'd find it helpful if we just went back to the grounds of appeal. You've taken us through and we've interrupted you endlessly. So I think it might be helpful if we just go back to the grounds of appeal.
Just before you go there, though, if you're about to leave the judgment, I don't know whether this is going to feature or not. I was slightly intrigued by paragraph 17, which does seem to reflect the intermediary's assessment. Where's the judge got paragraph 17 from if it isn't from the intermediary's assessment?
Yes, that was my reference before. He by the time he gave judgment, he had the assessment in front of him. I think the issue was how long he'd had it for.
So
Because this is a personal view, but these assessments are far too long. And why a judge should be expected to read 50 pages to understand this material, I simply don't know. But anyhow, he managed to pick up that information because he's clearly reading from the report at that stage.
yes, he sort of incorporated into
Yes.
the judgment which he gave, albeit he said at the start, I haven't seen it. I haven't looked at it, which is sort of a bit odd. In paragraph 9 he says, sorry, that's the cognitive.
yes,
Okay, so he did in fact sort of in some way assimilate, at least very perhaps superficially, the report which was presented to him during the hearing.
yes.
Okay, sorry, there was just simply clarification from my point of view.
My lord, just pick up on my lord Jackson's observations about these reports being too long. That is a fear of expert reports one has and all sorts of reports. One must be cautious, of course, that they ought to be as long as they are, as is necessary for each particular case. And the observations I've made in respect of this particular report, it was detailed, more detailed than some of the reports one has, and has the helpful table as to the particular difficulties this mother has and what measures could be used to assist her. That would be, I would submit, a useful element of the report without the additional 12 pages of narrative about matters which might not assist the court.
But the intermediary's report is not an expert report.
No.
Doesn't pretend to be.
It's not, but it ought to be a report that addresses the need for participation and how that participation might be assisted by the court taking certain measures.
I mean, this isn't a criticism, but it comes from somebody whose job it is to act as an intermediary and is advocating the use of an intermediary.
Well, that is why all parties accept that ultimately it must be a matter for the court. Anecdotally, it is observed that all intermediaries doing reports say that the party needs an intermediary. One must be cautious that one doesn't take that anecdote and therefore dismiss those cases where, on a proper analysis of the evidence before the court at that hearing, this particular party needs an intermediary for certain aspects of the proceedings and the hearing. But yes, my lord, intermediaries prepare reports, and part of their job description is to assist participants in court. One has to accept, and one must assume, of course, that those intermediaries produce those reports professionally and appropriately, and aren't simply trying to create work for themselves and their colleagues.
No, I was simply, I think, picking up the suggestion that the intermediary report is actually an expert report in any meaningful sense of that concept. It's produced by somebody that is their professional occupation, and they're in a sense offering, well, in fact this report doesn't even say it's doing that, it's attempting to assist the court to communicate with I'm just looking at paragraph 1.3 with the mother in the context of this case. Again, it might be useful to reduce the length of these reports if the authors of these reports, as it were, attempt to behave like experts, which they're not. I don't know whether that's what my lord was sort of getting at.
Well, I don't want to add to the number of things that one's thinking about, but the system that currently operates is that for some reason an intermediary assessment is triggered, quite often by a cognitive assessment, by somebody who is a recognised expert. And then the intermediary assessment is asked to make recommendations whether somebody should have an intermediary or not. And if so, that a different system could be devised where it wasn't up to the intermediary assessor to decide whether, or to recommend whether there should be an intermediary, but for the court to make its own decision about that on the basis of the psychological evidence before it or whatever other evidence there is. And the intermediary is simply asked to say what forms of support are needed. I mean, there is a perception, obviously, that because none of us has ever seen a report that says this person does not need an intermediary for just about everything. It may be we're not seeing reports of a different kind. It may perfectly well be that case. I don't assume otherwise. But this has led to the sorts of situations whereby we now have practice guidance, a perception, rightly or wrongly, that intermediaries are being deployed where they're not needed.
And deployed, and once the decision is made, not revisited or considered carefully, the instruction or the appointment of an intermediary might be a necessary step. It shouldn't always be considered to be a sufficient step, and one must always revisit that to make sure it is of use. And my lady, my lords, I go back to the observation I made, which is purely that of the mixed experience. In this case, I am clear that the person attending on behalf of the mother and the author of the report have undertaken their task with diligence and acted appropriately.
That's obvious from the report.
There are other cases, I'm very interested in this one, where an intermediary is appointed and then not entirely clear what active participation is necessitated by their friends. That is, I'm afraid, Mr. Jackson has identified another issue to add to an already busy circuit judge's consideration.
And a presumption seems to have grown up that they will be there for everything.
I think I go back to the need to look carefully at the instruction and be clear why.
And then be clear in the application to the court through the Part 18 process of what is sought.
And there's one other thing, while it's sometimes useful to be pedantic about these things, that the rules say that if you do not make participation directions for a vulnerable person, then you should give reasons for that in the order. I don't think, I mean, of course, it's not a criticism of the judge or indeed of those who drafted the order, but I think that doesn't feature in the order. There's a reference to the refusal of the application, but there's not, you know, it's a discipline to say we don't need participation directions because, or we don't need participation directions by an intermediary because this or that will be done. And that represents another safeguard against veering too far one way or the other.
My lord, of course, in this case, it wouldn't have been possible to draft that order. It wouldn't have been possible to draft that order to explain why participation directions were not required, because that detail was missing from judgment. I don't criticise Dr. Love for this. We are always required to perhaps ask for further clarification in a busy list of a judgment where one goes out of court to reflect, and by the time one reflects, the court has moved on. That's not always possible.
While we're on the order, we will let you sit down, I promise. But while we're on the order, I'm just looking at paragraph. It's page 98 in the bundle, and there's a heading intermediary assessment, and in that the court directs an intermediary assessment of LD. Now, but with a company called Triangle. Now, is that an intermediary assessment as we understand it? Just a different company? Much whispering.
Why don't I just turn
Yeah,
my
yeah,
back
please
towards
do, because people, this is the first time, isn't it?
So we have here a sort of just piece of randomness going on.
Would my lady ask the question again now that I have to?
All right, we'll try again. The intermediary assessment
Yes.
for someone else, in
Yes.
respect of someone, I'll just refer to them as LD.
Yes.
But it's Triangle,
Yes.
not the same company that prepared our assessment. And I was wondering whether this is exactly the same sort of assessment, but with just a different provider. Because if that is the case, which it seems to be because it's called an intermediary assessment, is I think it's something for us to observe that it says the expert to be instructed shall be Triangle.
Yes.
And so is Triangle an expert in the way that the other company isn't? Or are we getting into getting ourselves in a muddle about who's an expert and who isn't? Because it's presumably, again, would have been a part 18, not a part 25. And therefore, they're clearly highly skilled professionals, but for the purposes of family proceedings, not experts.
My lady, I will be corrected if I'm wrong by those who are present. That is not, it was not an expert assessment under Part 25. It was an intermediary assessment. The
And-
use.
Sorry, and it goes on down. The cost of that assessment should be borne by the local authority, which goes back to my Lord Justice Peter Jackson's early questions about who on earth pays and how's that decided.
I will leave observations to move from Mr. Howkins' house on behalf of the local authority.
Yes, of course.
One of the features in relation to LD is that at the time this assessment was directed, he was a minor.
Ah.
And Triangle, I understand, had particular experience in respect of minors.
The fact remains that well, let's leave it to Mr. Howe to explain in due course. And I just think that if we're going to have a sort of, we're being invited to do a bit of a tidy up, so that people are very clear how to get the best out of our intermediaries process, then we need to get our terminology right in our orders.
Grounds, my lady.
We know what you're saying, but I'd just like to tidy them up if you don't mind, please, Mr. Norton.
In terms of the bundle,
Page 14 of the call.
obviously, the paragraph ground one, the court was warring law to determine intermediary is not necessary for the mother.
Yep.
Is really linked, I think, with ground two, which deals also with the incorrect application of the relevant legal principles. Because I say on behalf of the mother that the judge heard, although he identified in the early part of the judgment the test of necessity, it is apparent, as I've taken maybe two in the judgment, the judge then looked at the exceptionality elements from the Northamptonshire case and the case of X and Y, and also in saying an incorrect application of the relevant legal principles, in saying incorrect, another word would be insufficient application of the relevant legal principles in terms of Rule 3A and Practice Direction 3AA. So round three, I've outlined that in my submission, that there was significant evidence, and my lords and my lady have gone through some of the evidence in the intermediary assessment, and also, as I've indicated, the opportunity for the learned judge, if he so took it, to hear from the intermediary himself. And again, 3 and 4, I think, are linked in
curious statement at the start of the intermediary's assessment to say that it's not to be regarded as evidence in the proceedings. What does that mean?
I think, my lord, the expectation is that it's evidence, as it were, that can assist the judge in determining whether a participation direction is. But it may be said by the intermediaries that what happened during the course of the assessment with the mother and the details of that might not be referred to in the proceedings. But I don't think that would hold in a for a judge hearing a fact-finding case, for example. If the mother or a party had said something in the assessment, it would be difficult to say that couldn't be used, as it were, as part of the evidence.
It's just very curious. I mean, the report says, first of all, I'm not an expert witness, and secondly, this report is not intended to be referred to as evidence within these proceedings.
I think it's probably to protect people from cross-examination about how good you are as a parent because of how you performed during the intermediary assessment.
I think it needs to be, if we're embarking at the moment on a bit of clarity in terms of who's an expert, who's not an expert, what the status is of these documents, it might be useful to at least that the people writing them need to understand that they may well be treated as evidence, at least for the purpose of determining whether there should be a direction for an intermediary or not, but perhaps not more widely, but that's helpful perhaps. Because I mean, you criticise, I mean, as I understand it, one of the criticisms you've just made is that the judge didn't take account of, how was it, you put the evidence in the case?
The evidence that was available.
The available evidence,
Yeah.
and one of the documents you say that you have regard to is something which says on its face it's not intended to be evidence.
My lord
Just
has picked up on a
making the point.
sentence in a report that I have routinely disregarded when addressing this court and others in terms of the substance of that report.
But it
It
would-
must be evidence.
But it would be better if the person writing the report actually, as we're focused on, again, I'm not criticising this particular, I've seen this sort of statement made repeatedly in other jurisdictions by accountants who well know what their report's going to be used for, but they just don't want liability to attach to any of them. I'm not saying that's this case, but it would be useful if we're trying to get our ducks in a row to actually make the point that the person writing this type of document ought to understand it may well be used as the basis for an assessment by a judge as to whether an intermediary direction is required or not. And then that's, so that sort of statement is unhelpful. I mean, that's just an observation, I don't, you agree or disagree.
Well, it's a helpful observation. Conscious in one's role is often required to think on one's feet. I might need a little bit more time to think about that. One can foresee, for example, a reluctance on an intermediary to be cross-examined on their report, for example. But yes, some further thought needs to be given.
Well, other than nobody likes to be cross-examined, I'm sure, but I mean, in a sense, they are making a report which they must understand the judge is going to have to form a view on. Otherwise, what's the point of it?
And you said yourself, she was there, she could have been asked questions. Well,
The danger, my lady, thinking on one's feet and needed to think.
no,
further
we're
about
working
this
it through
thing.
together.
And yes, no, there's nothing else that arose from that. Thank you.
Well, Lady, conscious as I am that all parties support, of course, it's subject to the appeal,
Yes.
and all parties are inviting the court to clarify, amongst the other matters already addressed this morning, the test being Rule 3A and application of Practice Direction 3AA without additional gloss. I'm risking, if I continue in my submission, is to simply say everything that everybody else to my right was intending to say. I will do so if it assists the court. If there are any matters specific to the mother, I can address at this stage.
No, thank you very much. You've been extremely helpful and coped very well with our constant interventions. So thank you very much. Yes, Mr. Howe, we'll try to be
I
less.
rise to my feet, my lady, having asked Milner Friends Jr. if his client needed a break,
Yes.
and I think the answer is yes.
Is she able to? Do you want to take a break, really?
Well, could she not slip out with her instructing solicitor perhaps, or
Yes.
you
Well,
know,
maybe
for because
I hope it was inappropriate. I didn't ask the mother whether she needed the proceedings to pause if she needs to leave court. So perhaps she could be informed that she is able to leave court.
of course,
and come back in as
Yes.
she pleases. I don't, on her behalf, invite the court to pause proceedings whilst that happens, unless the court thinks.
no.
or-
Well, if I can make it clear so that I think everyone understands, and but so that the parties and the grandmother will understand as well, is one of the reasons that we tend not to have intermediaries in the Court of Appeal is because we're dealing with a review on matters of law, and so it's. And that's why ordinarily we rely on counsel and solicitors to make their submissions to us. Of course, there's absolutely no reason at all why your late client shouldn't pop out for a few minutes if she needs a break.
Thank you, Madam. Thank you.
Thank you for raising that, Mr. Hand.
My lady, my lords, are aware that the local authority supports this appeal for
Yes.
the reasons we've set out in our skeleton argument. We say that a learned judge fell into error in he identified the right test as the court's already heard at paragraph 5 and paragraph 8 of his judgment, which is found at page 104 of the bundle, but then failed in our submission to undertake the necessary analysis, particularly of the factors in 3A.7. Again, he refers to that rule in paragraph 9, but then doesn't mention any of them at all in our submission in the later paragraphs. And as the court has heard, it then is distracted wrongly in our submission by the introduction of the gloss of rarity or exceptionality in the decisions of Mr. Justice Leaven and Mr. Justice Williams.
I think we could find it hard to say that he was wrong to be distracted, in the sense that he was applying binding authority.
Absolutely.
I mean, it's not a comment on the judge. It's a question about the validity of the authority. I mean, he had 2 High Court decisions, and he wasn't to know it. But a week later, presidential guidance to the same effect lands. And so I'm quite sure that we're not going to be critical of the judge for having regard to what he's been told to do by the High Court.
What he was required to do by the rules, my lord, is analyse the factors in a 3A, and it's our submission that had he done that, he should probably have come to another decision, despite his observance of the authorities that were binding upon him. We ask, we invite this court, and the court be aware that in fact it was my learned June invited this court when making the permission order to look at these authorities, so that the court is very much guided to concentrate on the rules as they stand when making these difficult decisions, often at case management hearings, when there's been little time. Another criticism that we say, perhaps understandable, but is made of this judgment is at paragraph 17, where the court's already observed that the learned judge did have sufficient opportunity to identify some of the characteristics of the mother that he describes in paragraph 17. But then in our submission, the judge does not engage with the recommendations made by the intermediary for addressing those issues.
Right, so left hanging.
Yes. So when the judge then says in the next paragraph that an intermediary is not necessary, the reader of judgment doesn't know why, and the judge relies on the court he says the court can ensure and will ensure various matters set out in the paragraph, but then doesn't move on to identify how that will be done. In our skeleton, the court will have seen we engaged with the detail of what the intermediary was recommending, and we've made our submissions of how counsel or any advocate acting alone would be unable to perform all of those tasks.
Can you help as to whether this was considered to be a ground rules hearing?
Not on my reading of the history.
Well, there's a mixture of heads nodding and heads shaking in the well of the court, because I mean it was complicated by the fact that at the end of this hearing the judge put it over for another hearing in order to see whether the fact-finding hearing could be rescued.
Yes.
But one of the things you have to have for a vulnerable person is a fact-finding, is a ground rules hearing.
Absolutely.
If the ground rules hearing doesn't have to be, it can be part of another hearing.
No.
And is it clear to the parties, maybe the answer is it isn't clear, whether this was considered to be a ground rules hearing?
Well, my junior's going through his notes. Mr. Froud did appear
Yes.
on the 15th of January, so I'll wait to be.
But just in considering this point, namely the left hanging point, we're not quite clear, speaking for myself, as to whether the judge intended to revisit this question ahead of the fact-finding hearing in order to say what the rules were.
Yes. Well, one of the requirements of 3A7 at K is whether any measure is available to the court. So as part of the evaluation of whether an intermediary is necessary, in our submission, the court has to engage with what measures the court can deploy to meet the assessment of vulnerability that's already been made by this judge, and to address the characteristics not just of this mother, but also of the hearing my lord has already outlined earlier, to enable public participation, and that didn't happen.
Well, so in answer to my question, I think we understand that the court was required to hold a ground rules hearing. And so the question is whether this was a ground rules hearing or whether at this hearing the judge made arrangements for there to be another ground rules hearing.
May I just tell me that? I'm told that this hearing was listed to consider the further instruction of an intermediary for the fact-finding hearing and any ground.
So it was
rules.
intended to be the ground rules hearing.
Yes. Two purposes. Yes.
And did it perform that function, or did it pass that on to another occasion when it was going to be performed?
So I've been told that a further pre-trial review hearing was listed.
Well, we know that, but that's all to do with rescuing the fact-finding hearing. Nothing is said in the order that I picked up or in the judgment that says we will come back to this in order to identify exactly what the rules are going to be.
No, because the order at page 97 simply says the application for an intermediary instruction is refused, and no further directions are made.
I just want to have a notable that it said on your behalf that although it was intended to be a ground rule hearing, it was not, and no substitute was directed.
Clearly not in the order. No. Just whilst addressing the order itself, because my lady raised the order of page 98 for the intermediary assessment of the young person who's an intervener. That order is not the recommended prescribed form of order for an intermediary assessment as set out in the compendium of private law orders. It's order 7.2. They're the same in public law and private law. It's paragraphs 25
Do we have
to
that?
35.
Do we have that?
I've just pulled it up whilst the court's been engaged in asking questions about this order. I can send it through to the court at short adjournment, and the court can see in the recommended precedents, in fact, my Lord's point, that the court, the draft says the court has concluded there are currently no parties or witnesses for whom it is necessary to make a participation direction because, and then should give the reasons. So there is an approved a form of order for this type of application, and given the points raised by my lady and my lords this morning, observance of that precedent would clearly assist the parties, the advocates, and clearly the judge. And turning back to the appeal itself and the judgment. When the learned judge reached his decision, in our submission, there's an absence of necessary reasoning, which we've already addressed, and really from that basis onwards, it's impossible for the reader of the judgment to understand why that decision was reached.
Can I just rewind a touch? Did I hear you correctly that you said you accept the judge applied the right legal test?
He identified the correct legal test, because if we turn to paragraph 5 and paragraph 8 of the judgment, paragraph 5, the judge says there are two issues. Firstly, should the court ask itself if Miss Streeter is vulnerable? Question mark.
Yeah.
There is no doubt in my mind that she is a vulnerable individual.
Yeah.
The court then has to proceed to the next stage and ask itself whether or not it's necessary there to be an intermediary. So in summary, that's the right test. And paragraph 8, the judge says the task is a simple one. What are the participant directions that are necessary to ensure that the mother has a fair hearing?
So, and as I understand it, you'd say that what he then goes on to say that encompasses her ability to participate in the proceedings and also to give her best evidence. That's a sort of paraphrase, is it, for 3A.6? Is that right?
Well, the obligations are set out in 3A.4. The court must consider whether a party's participation in proceedings other than by way of giving evidence is likely to be diminished by reason of vulnerability, and if so, whether it's necessary to make one or more.
Assuming we're not talking about the vulnerability assessment here, we're just talking about the second stage. Is this right? You read 8 as in effect, encapsulating the two limbs of 3A.6. Is that right? Participating in proceedings and giving evidence, which he's.
Well, 3A.6 is about protected parties. So, protected parties are litigant that formally lacks capacity.
So where does he get that from? Where do you get that from? Because I thought this is. So where does that test come from?
The test of a necessity for whether or not to deploy a particular participation directions. So, paragraph 8, the test is simple. What are the participation directions that are necessary to ensure the mother has a fair hearing? Well, in our submission, that is the test. In assessment of 3A.7, the rules require when deciding whether to make one or more participation directions, the court must have regard, in particular, to all the matters listed.
Where does necessary come from?
In relation to participating in the proceedings or giving evidence, so it comes from 3A.4 and 3A.5. Whether it is necessary to make one or more participation directions appears at the end of each.
So that's where someone is not a protected party. That's the equivalent of 3A6, 1A and B, but
Exactly
split
right.
into two separate rules.
Yes.
Okay.
There's
Sorry,
no
right.
suggestion that the
Okay.
mother here is a protected party, so we're dealing with.
No.
That wasn't actually going to be my main question, but I was just trying to lead up to it. The main question is, what do you say about paragraph 14? The second sentence particularly. Is that correct? As a matter of law?
Yes, an intermediary should only be considered if the alternative participant directions will not ensure that the mother can give her best evidence and participate fully in the proceedings. The authority entirely accepts that. If
Is
other
that right?
measures,
Is that right? It's a last ditch.
Yeah, that's what I was.
It's the word considered, isn't it? It should only be instructed. I mean, it would follow, wouldn't it, that if it's necessary and it isn't, then you're not going to instruct. But it considered is maybe just a loose word.
if there are other measures that meet the needs of
Then it
the
won't be necessary.
party or the witness and meet the needs of them at that hearing,
Yes.
then an intermediary is not necessary.
Well, one of our interveners it came back to the holistic linear analogy, and when you don't sort of go along one line. I mean, you look at the situation and you elect where it's appropriate.
Yes.
Could you just before for my note, you gave the standard orders. You said 7.2, did you?
Yes, it's order 7.2, private law case management directions,
Right.
and it's paragraph 25 onwards. They're probably replicated in identical form in a public law compendium. I'll look over the short adjournments, but
Right, and there are repeated emanations of this, aren't you? The edition I had didn't have it at 7.2, but it's
yes, this case, my understanding is this was introduced in 2022. Again, I'll check that over the short adjournment. I was looking for it whilst my friend was.
Well, because obviously, if there is out there a standard order, whether people are using it or not, we ought to be aware of it.
Absolutely.
Can we go back to what you were saying to us about 3A7? Because the heart of your submissions about where the judge went wrong was you said he failed to take into account the factors of 3A7 and had become distracted by rarity. Is it your case then, in support of that when judges are considering these applications, usually very speedily in very short hearings,
Yes.
we could think by analogy to applications for joined as a party under Section 10(9) Act 1989, where what we see always is a sprint through the factors that are set out at Section 10(9), dealt with usually just in a couple of sentences by the judge, as a means of ensuring you've had compliance with those issues that you have to consider without ending up having to spend 5 hours writing a 10-page judgment.
Yes.
Is that the sort of approach that you're suggesting judges should take?
The judges need to ensure that they're taking into account what the law requires, not just identify the appropriate rule, which this judge did. But then in our submission, there are mention those particular factors from A to M which were of importance in the decision that the court.
Well, presumably you would have said that, for example, 3A7E, whether the matter's contentious.
Yes, very much so. Also D.
And D, the issues, but which are
Complicated fact-finding hearing, difficult
medical
evidence.
issues, very serious allegations.
Yeah. So that should have been mentioned, and as we've already submitted, K, where the judge is finding that an intermediary is not necessary because the court can manage the needs arising from the vulnerability itself, then the court needs to identify what those measures are and need to balance those against the application for an intermediary, so that a reasoned judgment is being given that analyses the alternatives.
Whereas here, what happened? No such balance was conducted, and heaven forbid we go into tables But what actually happened was then it went off to a future ground rules type hearing to look at what alternative participation orders could be made, directions could be made, instead of thinking, well, that could work, so we don't, an intermediary is not necessary.
In our submission, that should have been done at the time the decision was made,
I understand.
rather than it being deferred until
Yep.
later. If that's the reason why the application fails, then that needs to be analysed when refusing the application.
So the danger was that the approach was, this is not one of those rare cases where an intermediary is necessary. We'll work out what alternative directions to make on another occasion.
Yes, yeah, my lady has the point.
Thank you.
Turning, if I may, to this SCOTUS argument filed on behalf of the local authority, and just adding really some additional points that may be of assistance to the court. We say at paragraph 19, which is on page 44 of the core bundle, that the intermediary assessment in this case did not refer to the assessment made by the psychologist, the cognitive assessment, and we make an observation that that's not unusual, and it's a point that Mr. Justice Williams addresses in the Oxfordshire case, which my lady and my lords will find in the authorities bundle at page 97. Paragraph 6 of the judgment, where Justice Williams says the author does not seem to have been aware of the reports of the psychologist, did not have access to them, or even a summary of the results of the psychometric testing. And he says it will usually be critical that an intermediary is provided with an expert report which addresses the cognitive abilities of the parties and any issues which bear upon their vulnerability, as these are specific considerations for the court in determining what participation directions are necessary and clearly relevant to the intermediary assessment. And on behalf of local authority, we endorse that position. As we say in our document, it's not unusual at all for there to be no mention in the intermediary report of the cognitive assessment that the court relied upon in making the order. And in our submission, the intermediary's assessment is informed, can only be informed by the expertise of the psychologist that's met and assessed the party or witness. So when this court gives, if this court is prepared to give tidying up guidance on these issues, that is an area identified by Mr. Justice Williams that we invite this court to support, so that the recommendations made by an intermediary are targeted to the assessment that's already taken place. And of course, the intermediary is a communication specialist, and so having that information and referring to it would, in our submission, give a greater weight, if that's the right word, to the recommendations they then make. Moving back to our skeleton argument, I don't want to repeat what's been said already, so I will jump about if the court's content with that. Paragraph 28, we say in many cases vulnerabilities of a parent are, as happened in this case, identified pre-proceedings. And of course, the social worker in this case identified this mother's vulnerability and communication issues in three points in the original statement. And so in our submission, where this court is considering how an application for an intermediary should be made and what evidence, if any, there needs to be in support of it. We agree with the submissions already made that there was evidence in this case upon which an application for cognitive assessment could be grounded. Indeed, an application for an intermediary assessment, and the PLO requires a social worker to address issues of vulnerability in the first sweat, and that's addressed. I'm afraid one thing I'm old-fashioned about is my red book rather than technology.
Well, could I just use the opportunity to say that, in common with many family cases, the bundle doesn't include it doesn't include the rules, and it seems to be thought that authorities are just what judges have said, and so I mean, as we have powerful team in this court, could it be got around that in appeals, the first thing in the authorities bundle should be the rules on which the appeal is turning?
My lord, we actually discussed this amongst ourselves, and we were slavish to the guidance that in the relative rule for, and only included authorities rather than the rules.
So the answer, your answer is that we need to look at our rules, is it? Because whatever it is, in all other disciplines, what I'm aware, one gets the statute even if people know it by heart, and one gets the rules even if people know it by heart. And that ought to be the case here, because it prevents you having to go to red books. It prevents us having to do the same.
Well, if there is any ambiguity, clearly there is, because we've fell into it. We invite this court to correct that in this judgment. So all of us who appear in this court know.
So the preparation for members of the Constitution who are not specialists is who may not have a red book sitting on their desk the whole time, or even be not wholly clear what it is.
Or at all.
No, completely understood. It makes perfect sense. We thought we were doing the right thing, following the guidance.
But I'm sure our judicial assistants are going to be getting onto this. This hearing is over, and get this right.
So turning back just to some updating points, if I may, the a debate, if that's the appropriate label, as to whether the court should be directing intermediaries only for a hearing, or to assist in consultation with lawyers at court, or to also to assist with lawyers out of court. It's Rule 38A, which is entitled Measures.
Rule 38A.
Rule 3A.8.
Oh, sorry, yes, thank you. Measures. Yeah.
3A.8. Measures. The measures referred to in this part are those which A, prevent a party or witness from seeing another party or witness, B, allow a party or witness to participate in a hearing and give evidence by live link. If we can go then to C, to use a device to help communicate, and then we have D or E. Provide for a party or witness to participate in proceedings with the assistance of an intermediary. Then a separate measure is provide for a party or witness to be questioned in court with the assistance of an intermediary. So in our reading of the rules do contemplate both the intermediary being present when questioning in court is taking place, and an intermediary being necessary for other meetings.
But that cross-ruffs it, doesn't it, to cross-ruffs to 3A, 4 and 5. 4 and 5 you consider, those two, and then at 3.8 it's implementing measures.
Yes.
Having
Yes,
considered
so they link straight through. So in our submission, the rules do provide for what my learned friend, the appellant, is asking for.
Well, that requires. Can I play devil's advocate? that does require you to be a little more extensive, because E is to provide for a party or witness to be questioned in court with the assistance of an intermediary. That's to help the person who is being questioned. And D is to provide for a partner who is to participate in proceedings with the assistance of an intermediary. I think you'd have to say that if an intermediary is going to be directed to assist in the solicitor's office, it would have to come under D, wouldn't it?
Yes. Agreed.
And it does require you, I think, then to expand the concept of participation in proceedings to encompass something outside the courtroom. Because, I mean, D could simply, playing devil's advocate, be limited to the intermediary assisting the party, say, to understand the questions that are being put to another witness or the answers that are being given or the court proceedings. And you go back to the definition of intermediary, and maybe you could actually get your submission, or you could potentially support your submission by pointing out that the definition of intermediary does not seem to be tied to any geographical or temporal limitation. It just simply says a person whose function is to communicate questions put to a witness or party, to communicate to any person asking such questions the answers given by the witness or party in reply to them, and explain such questions or answers. But playing devil's advocate, somebody would say, well, come on, of course that means questions and answers in the court. It doesn't mean questions and answers in the street or the solicitor's office or anywhere else.
The solicitor is seeing the client for the purposes of the proceedings. They're taking instructions, they're preparing written evidence, they're complying with court directions. The proceedings, using its ordinary word, is the court's application for the point of issue to the point of determination.
But it may well be that the other answer is that in 3A5, the quality of evidence given, is given in part in modern proceedings by way of statements. And so you have to read the definition of intermediary and the provisions you've done in the context that somebody's quality of evidence is going to be enhanced if it's prepared in the right way, or responding to somebody else's evidence. But you do need to plug all these bits together, I think, to get
yes, well,
where you need to get to. You can't just sort of, I don't think you can, in isolation, just focus on the word proceedings, because it doesn't really quite get you home, I think.
Well, I don't have it all at my fingertip, but the family procedurals require the party's case to be in the statement. The advocate then has to ask permission of the child judge to ask any further questions. So the evidence in chief is all contained in the statement.
Yeah.
But you do need to plug all these bits together, I think.
That's why you're being handed 3A5 by my lord.
Yes. Well, absolutely. I'm grateful for the gift. Yes, the proceedings, I say, they encompass all the hearings, following the application, and the requirement to assist with the provision of evidence is not just limited to the witness box. On the same point, and I indicated I had the guidance available, and again, this is something that I've been pulled up overnight, trying to anticipate what questions the court might ask. The guidance on remuneration of expert witnesses in family cases, this is the Legal Aid Agency funding guidance dated the 10th of September of 2024.
An intermediary is not an expert witness.
All I can do, my lord, is read what the guidance says. It's under a heading, communicating with the client, intermediaries. So paragraph 5.33 guidance says the LAA will not fund fees charged for witness intermediary services provided in court, or reports in advance of the provision of such services, or other work in preparation for or ancillary to court proceedings. Where an intermediary is required for a hearing, an application should be made to HMCTS.
So does that come out, we won't pay anything for anything to do with an intermediary, or was there some bit they will pay for.
That's what that paragraph says, but there's a paragraph 5.34 that then says funding can be provided for an intermediary / lay advocate to be used for communication between a provider and their client away from the courtroom in the course of the legal representation provided, subject to the legal aid authority being satisfied that it is a justifiable and reasonable disbursement.
Does that somewhat copy the practice in relation to interpreters then?
Yes, and a lady, my lord, may recall from daily sitting as a first instance judge, solicitors are often very keen for the court order to say what is a reasonable disbursement in terms of experts, for example, so that they can then make an application for prior authority. My understanding is that an application for prior authority would need to be made to the legal aid authority for the solicitor to be assured that the money.
So if there was the power to have an intermediary for a conference, then that would not be paid for by HMCTS, and there would have to be prior authority for it to be paid for by the legal aid agency.
I would say it wouldn't have to be. The rules in the submission I made a moment ago allow for it to be directed. The rules don't say who is going to pay for it.
Well, it does. I mean, Rule 3A.8.4 says nothing in these rules gives the court power to direct that public funding. It must be available to provide a measure.
No, but the funding guidance I've just read out provides that funding can be available for an intermediary
So in
support.
practical terms, if the court said that there is to be an intermediary, and it considered it had the power to say for a conference, then the solicitor would use that in order to seek to be remunerated for the intermediary's fees.
Yes, and if that matter was raised with the court at the same time the application was made for the intermediary for the purposes of the in-court interaction, so in the courtroom and in a con room outside the court, and the judge was prepared to make an order or even a recital on the order that in the view of the court.
In intimation, because there's no power to direct it.
No power to.
So I'm a bit bothered about this guidance because so far, well, that's 2 errors in it, and I'm about to flag up a third. So 1, they're not experts. 2, the court can't direct what they're saying they might do if they're directed. And 3, it refers to a lay advocate. Well, if you said lay advocate to the president of the family division, he would say there is no such thing. He would say you can have a Mackenzie friend or you can have a professional advocate. There's no such thing as a lay advocate.
Well, I've read to the court what it says. It provides a mechanism by which solicitors representing parents with vulnerabilities can make an application for funding for an intermediary outside of the courtroom. But
so why in our order did the local authority say they would pay for the assessment of LD? Was that because LD's a minor? And
well, the order at page, I think it was 98.
Because the assessment should be borne by the local authority.
The costs will be borne by the local authority. Yes, I'll have to perhaps over the short adjournment drill down into that as to why.
I'm sorry to be the backmarker on this, but is the practical understanding, whatever the rules and guidance may say, is that if there are intermediaries in court, HMCTS will fund that.
Yes.
And if there is a power to have intermediaries outside court, there appears to be a route through the guidance by which that might be reimbursed by legal aid.
Yes.
And it would make sense if the court order was there, because otherwise they certainly won't accept such an application.
Yes, there is a route available. The time taken is another matter, and the court will see when it has an opportunity to look at the precedent order. The precedent order requires the intermediary service to provide a quotation to the court manager, for the court manager to consider for 7 days, and then for the matter to be listed for further case management hearing once the court manager has accepted
Yes.
the quote. So when my lord was raising earlier about an order being for a certain hearing and then to be revisited, or for certain witnesses and then to be revisited, the difficulty with that is the intermediaries at court would then have to produce an estimate, which then goes to the court manager, then has to be approved by the court manager, and then approved by the judge. So that all builds in practical consequences in the management of a hearing if there's not permission for the intermediary to be present for all of it. It's not unusual in our experience for orders for intermediaries to be made for the expert witnesses, for when a parent gives their own evidence, and for the lay evidence, not to require an intermediary because the team around the party can, with frequent breaks being taken, make explanations. But of course that's not every case, and that wasn't the recommendation in this case with this hearing and with this.
So far as the standard rule is concerned, there is this complex rule, which I can see what you're referring to, which is to do with getting the okay from HMCTS that it will pay for the standard assessment, which came out at £800 or whatever it was for the other individual in our case. But the standard rules do not provide for a similar process of control by HMCTS over the appointment of an intermediary following an assessment. Is that right?
Yes, well, as the court's pointed out, the rule does not give the court power to direct public funding.
No, I wasn't talking about pressing the accelerator. I was talking about putting on the brake. That it is a decision for the court once it has all the material it needs to decide on whether there is or is not to be an intermediary. The court does not then have to go to say HMCTS should be asked first. If the court has decided that in order to conduct an Article 6 compliant hearing, there has to be an intermediary for this, that, or the other purpose within the court process directly, then that's a decision for the court. At that stage, you don't go back to HMCTS and ask.
Well, practically, and I can say this from experience, the intermediary won't show up or won't come back unless they submit. The agency has been told the court's approved your fee.
Right. But that's not for the judge to ensure by means of an order. At this stage, I mean, clearly, if there was a problem, the judge would have to deal with it. But the standard order makes sure that intermediary assessments are not carried out without HMCTS's prior knowledge. Is that how it works?
Yes.
Right.
The quote has to be submitted to the court manager for approval, and then at the ground rules hearing or an earlier pre-trial review, the intermediary assessment is considered, and the judge makes a decision as to whether the intermediary required at all for the hearing, and if they are required, which days. And again, experience tells us that since the decision in the Northamptonshire case, but rather than it being an expectation that the intermediary would be present for the whole of the trial, the converse has been true, as has been set out by the interveners in their submissions. And we invite this court really to correct.
You say both are wrong. You say both positions are wrong.
Yes. The judge has to make a case-specific decision and a hearing-specific decision, because the demands are different for a complex fact-finding hearing with medical evidence, which any litigant needs an explanation of, but a witness with vulnerability will require more time for that explanation to be given. And of course, explanations can be given and are given prior to the hearing, but then oral evidence takes place where the challenges occur, the challenges that are really important to that party's case, and that all needs to be explained alongside all of the lay evidence. So there are certainly, the local authority position is that the decision being made has to be client specific and also has to be hearing specific, because the measures required aren't always identical for every hearing. Of course, the problem with that is that's taking up more court time at every case management hearing. Just turning quickly, if I may, before the short adjournment, because we raise the issue of whether evidence is required to make an application for an interview.
Just before you do go on to that, can I just raise a point which may not be a point, but my Lord Justice Jackson mentioned an analogy with interpreters. And I have a recollection that the position in relation to interpreters is somewhat different in the sense that there are interpreters which are for use in court who, generally speaking, have to be independent.
Yes.
And that's quite different from the costs of interpreters that are engaged privately by lawyers to enable them to communicate with their client. And there was a case, which certainly I was involved with a little while ago, about the different cost regimes and recoverability of cost that apply in relation to those two different things. Here, as I understand it, you're saying that the rules give the court power, we've looked at them, to say there should be an intermediary not just for court hearings and everything that goes with court hearings, and I'll include in the courtroom and outside the courtroom within that, but also what goes on privately in the solicitor's office in relation to the preparation of evidence. Now,
yes.
I assume that's the power. The court just gives a direction that it regards that as necessary to ensure a compliant, fair hearing. Doesn't say anything about who's going to pay for those two different scenarios, and just what leaves it up to such authorities as there are to decide between themselves which of them can or will pick up the tab. Is that right?
I would disagree. I wouldn't expect any experienced or even inexperienced family court judge to make an order for an interpreter or an intermediary without considering who was going to pay for it. So if the application is made on the basis that the court pays for it and the judge is satisfied with that.
Okay, well, you've preempted the question. I was going to lead you more gently to it, but how can we, without hearing from the likely funders of this, start pontificating about what courts should and shouldn't do? Why haven't we heard from HMCTS or the Legal Aid Fund or indeed local authority? Well, you are the local authority, but as to whether they agree with this regime you're putting forward, because they're the people who will have to bear the cost in due course.
This is their own guidance dated the 10th of September 2024. We're not introducing anything new.
Okay, but it's a shame they aren't here then to answer questions about their guidance, because nobody seems to have told them.
Yes, well, the requirement on the solicitor is to satisfy them that it's a justifiable and reasonable disbursement. Paradoxically, perhaps, I was about to come and talk about what evidence might be required to justify that, whereas if you tell the court or the legal aid authority that my client requires an interpreter because their command of English isn't good enough, I'm not aware of circumstances in the family cases I've been involved in where that's ever been a challenge and the interpreters provided by the court or the LAA pay for one. So if that answers my Lord's question, if I could then move on to the issue of the evidence that it should be required or should not be required. I say should not be required because of Rule 3A10 and Practice Direction 3AA 6.1. 3A10 it's headed Application of Directions under this part. An application of directions may be made on application form, and then it says 2, the application form, application notice must contain the matter set out in Practice Direction 3AA. Practice Direction 3AA at 6.1 is headed matters to be included in application form for directions. And then it says an application directions under part 3A shall contain the following information as applicable, and then lists the matters for the court to be included for the court to consider. You know, a view about whether the party or witness would benefit from assistance, the measures that would be likely to maximise as far as practical the quality of that evidence, why those measures would be likely to improve the person's ability to participate, why the measures would be likely to improve the quality of the person's evidence. So it goes to my Lord's point about the draft order, because if the application is made and complies with 6.1 of the practice direction, then the court's getting the information that it needs and the reasons for it. And the rule doesn't require evidence. Of course, the Part 18 application form has to be signed by the solicitor on behalf of the client, but there's no requirement for any evidence. So where indeed in the President's guidance there's an expectation for evidence, that's not something required by the rules, and we align ourselves completely with the observations made on behalf of the FLB and the ALC that having the lawyers draft statements with statements of truth to give their impression of their client as requiring this special measure is, we say, not one step too far, but 10 or more steps too far. The rules don't require it. The court needs information. The information can be provided in the application form as already prescribed. And if the professionals need reminding to go back to that, then we invite this court to say so, because again, that assists the judge in the busy list to have the information that he or she needs to make these decisions.
So are you saying in which case you don't need an intermediary's report, such as there was in this case? Or, I mean,
in cases such as this, where the local authority has limited involvement with a family pre-proceedings because there's been an injury, for example, and it's the first time that a social worker had contact with the family, they may well not have enough contact to pick up there's a communication or cognitive need. So the solicitor who is then asked to attend the first hearing to meet the parent might be the first person who makes an assessment by just simple questioning and asking questions about what occurred to realise that there's a communication issue here, and so then they can use their experience of the client to make an application under the rule I've just outlined, give the information required by the practice direction, and then make the application for that to be heard. And that doesn't necessarily.
Without any evidence in support at all.
It doesn't. Yes, it doesn't. It doesn't require always, and there are in some intermediary assessments that occur without a cognitive assessment having taken place. So the cognitive assessment doesn't necessarily come first. In my experience, there's been cases where there's just been intermediary assessment. I would say it's usual to have a cognitive assessment and then, but the rules don't actually require it. The rule requires an explanation of why that measure is sought and why it said that measure will improve either participation in the proceedings or the quality of the evidence to be given.
Oh, is that a convenient moment?
It is, lady. I will then review what I had left.
Yeah.
If I have anything.
Could I just,
Of course.
I find it helpful if you could just take us briefly to the main authorities that are referenced in the written submissions, just to identify the parts of them that you seek to support and say are sound, and the bits that you're not so sure about. So we could just see, have at least a high-level view of what your case is about that.
I'll certainly prepare for that for 2 o'clock.
Thank you.
Thank you very much. 2 o'clock, please, everybody.
Court rise approval.